What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. It is a new year. We got new challenges, new laws, new changes. Let's start it off from there. I'm Mark Zinman. I'm one of the attorneys here with Zona Law. I'm joined.
I'm Scott Baluha, and happy late New Year.
Yeah, happy late New Year to you as well. We thought about getting on a podcast earlier, but January 25th, things change, and that's when we jump on and give you guys new information. So we're going to jump right in here and figure out what's going on in the landlord-tenant world and what you need to know today. So what's the newest change, Scott?
Well, we've been getting a lot of emails and phone calls about a recent paper that was put out by the White House called
How recent,
White House
Scott?
Just today. Today is January 25th, 2023, and today the White House did send out a new blueprint for a renter's bill of rights. And just generally, this blueprint is set up so that there's several different federal agencies that the executive branch of government has control over. And they want to put out there, well, what generally are we going to try to push all of these different agencies to do? So the key thing to remember here is that there's nothing that you need to do immediately. However, you need to pay attention to what is coming down the line and to start adjusting course to prepare for these.
Yeah, this is not, we're going to go through the details of it. What's important to note, this is not new laws coming out. This is basically the White House's interpretation of existing laws, how they want their agencies to act, how aggressive they want to be regarding policies protecting residents. So don't change anything overnight, but you do need to realize this sets the tone of what happens, what actions are taken against landlords. And so they need to we all need to understand what that looks like because the landscape is changing. And I think before we jump in, though, I want to explain, kind of, I guess, give a disclaimer, if you will. We're not going in here today on the difference in the executive branch, the legislature, all the different branches of government, the powers that be. This is really just to advise clients of what comes in this paper and in the blueprint and what landlords need to know. So with that, the blueprint breaks down in 5 different sections. So what are we looking at here?
Yep, like you mentioned, there's 5 different sections that the White House is going to focus in on. Generally, those 5 categories are the safe, quality, and accessible and affordable housing, clear and fair leases, education, enforcement, and enhancement of renters' rights, the right to organize, and eviction prevention. And we're going to kind of talk about each one of those individual categories so that we kind of know where we're going to be going with this. All
right, well, why don't you kick it off for us then? Since safe, quality, accessible, and affordable housing, what does that even mean?
Well, just think about it from the perspective of if you're a property manager, well, you have an obligation to provide a fit and habitable unit to rent out to those individual tenants, right? Well, this is just a much more broadly federally based program to ensure that there are minimum requirements that all units that are subject to these types of regulations must have. And what kind of units is the White House proposing are going to be subject to these types of protections?
Well, of course, again, generally all of these issues, landlord-tenants, have always been state rights. So you have the states set forth these issues. Here, the federal government's coming forth. And so, as we've learned since the pandemic, they're trying to touch, the federally backed mortgages and at the same time really create a policy that they hope everybody else follows. And so when I say they hope other people follow it, I mean they have some teeth behind it as well. But their launch into the landlord-tenant world comes through Freddie and Fannie and the federal mortgages, and then they kind of push out what they hope the industry is going to follow as well.
And from a practical perspective, you may have already experienced some of the federal intervention into your daily processes in terms of serving non-payment of rent notices. If you've served any type of 30-day notice, that is the federal government having an impact on how it is that you're going to be managing your property. And it's with that in mind that we need to go through each one of these categories.
Yeah, and then they're also with that, under that same provision of the quality, accessibility, and affordable, is they're going to also be tweaking how Fannie and Freddie look at the loans they're buying, whether, the qualifications of the residents and how much they can charge for those amounts. And that's what, a big part of that we're going to see, and we have to wait to see how that actually plays out. The second one, though, is clear and fair leases. What does that mean?
Well, in the Residential Landlord and Tenant Act and in the Mobile Homes Residential Landlord and Landlord-Tenant Act, there is an obligation to make sure that you have lease terms that are somewhat clear and unambiguous, and to make sure that you have provisions that are clearly understood. Nobody wants to be blindsided by provisions that they didn't clearly understand, and that's really what the focus of this particular point is from the White House.
Yeah, and I don't even like that connotation, though. It's like implicit. They're trying to say that landlords intentionally do this to take advantage of residents, which our clients don't do that. Like, we say this a lot, is our clients really do run a clean ship, really a good business of being housing providers. And the tone under this is that landlords don't. And even in the blueprint, the White House actually says, I can't remember what state they referenced, but there had been testing done and showing that over the past couple of years, unenforceable or illegal provisions are actually becoming more common in leases. I don't see that in our practice, but that's what they're trying to fix. So they're saying they're going to be looking at hidden and illegal fees, arbitration, false representations of statements made in the lease. That's the kind of thing they're focusing on the second block as well.
And there's not a week that goes by that I don't get requests from clients asking to modify the language in the lease to make it more clear. It's not that the goal is to hide the ball. It is more about making sure that it's clear, so that if the worst case scenario happens and you need to file some type of eviction or legal action, that you'll be able to clearly explain to the court, well, why is it that this needs to be enforced the way that we're reading it.
I will tell you two funny things, one to remember. Two things. One, after all setting forth this, and the White House wants leases to be more clear, they even wrote in the blueprint, they're like, yeah, but most tenants don't read leases, which I find that funny. And then two, they actually say unenforceable provisions, they don't want arbitration provisions in leases either. Now, that may not seem like a big deal to the viewer right now, but we're going to touch on that later, where they basically come back later in the 5 points and actually contradict themselves as to that. So number 3, education, enforcement, and enhancement of renters' rights. Well, what does that mean?
Well, the biggest key here, or biggest takeaway for me, has to do with enforcement of fair housing violations. The White House has made it clear that their focus is to make sure that they are interpreting the fair housing laws as it applies to landlord-tenant relations, and making sure that tenants have equal access to rental properties. As such, they're going to put more money towards the enforcement of fair housing laws and making sure that compliance is more is focused on a lot more. And if you've listened to any of our prior podcasts,
which
we've already
of course,
talked
obviously you
about,
have.
right?
I mean, why wouldn't you watch all
of
them?
Then you know that that's one of the things that we've been stressing. We need to make sure that we are conscious of the implications of fair housing, even for something as simple as a due date on a lease agreement. We need to make sure that we're comprehending why it is that those things are important in not only applicants, but also our existing residents, and it's applicable to everybody that works at the complex, not just the on-site manager.
Yeah, and I think with the fair housing point here, this is a good example of what the bigger bubble picture of this entire blueprint is. We already know fair housing exists. It is a law that's on the books. The Biden administration is just putting an extra emphasis on it and saying that their agencies are going to be much more proactive, much more aggressive going after landlords, and that's what should be taken from the blueprint. It is that tone that landlords need to be aware of, as opposed to a single law changing overnight. What's interesting that's also in the blueprint there is they mention the idea of source of income as a protected class on a national level. Now, the White House acknowledges they don't have the authority to actually just implement that. It was almost like a wish list that was put out there.
Right, and that kind of goes to our key point here, is that all of this is under the caption of, well, this is what we would recommend. This is what we want each of these different agencies to do, and ideally this is how we interpret those laws. Things are going to change, which is why you don't need to necessarily take any immediate action, but know that these are going to be things that they are going to focus on.
Yeah, and a part of that as well under the education enforcement, another branch, the CFPB, another agency, they're talking as well about background checks, what's allowed, and they're, again, implying that people are being improperly weeded out on the application process. And that's something that's going to be delved in more by the CFPB and learn what the standards are that the White House wants.
And already in Arizona, we've seen a push in changing the law here to make it easier to seal eviction records and make it less accessible to be able to find them if a case has been dismissed or if a tenant prevailed in an eviction action. It's those same types of local things that have been happening that are now going to potentially take place on a federal level.
Yeah, and we've talked about this time and time again. What you see in the news is what causes laws to be passed, causes these types of actions. And it's the rhetoric of the big bad landlord that keeps coming out. And it causes the White House to put out this type of blueprint and to change the narrative or to change the landscape of the business that you're operating out there. So number 4 is the right to organize. When I think that, I think unions going in like Starbucks and business. What does it mean here?
Well, in the context of what the White House is proposing is essentially creating a federal protection that talks about the ability of individual tenants to set up unions and to organize and to collectively act towards putting together a tenants union. There is already protections under the different acts that are applicable in Arizona when it comes to landlord-tenant laws that protect tenants. And if you try to discourage a tenant from engaging in this type of activity, then you could end up being subject to potentially fair housing violations, but also violations under the applicable statutes, especially if you were to move forward with an eviction action, knowing that the tenant is engaging in this type of activity. So there's already protection, so there's not that much that would change for the state of Arizona, but certainly on a federal level, it would affect other states.
Yeah, and that's why it's so interesting to me having the federal government come and touch on these things, because landlord-tenant relationships in all the different states, as people like to simplify and say, oh, it's all the same. It's not. Your rights in, let's say, a 1-acre ranch that you're renting out in Gilbert is going to be very different than a 2-bedroom condo that you're in New York, and the laws in the states account for that. Having the federal government come in and do these types of things is kind of mind-blowing in that perspective because it has been a states' rights issue. But again, the right to organize for us, not a big issue, and it's already prohibited by state law here. So the meat that's left on the bone here for us is the eviction, prevention, diversion, and relief. And like all others, Baluha, what does that even mean?
So again, as a diligent watcher of all of the prior Zona Law podcasts over the last couple of years in response to the COVID-19 pandemic, there were certain acts that were passed by Congress that talked about, well, what kind of protections are we going to provide to renters to help keep them housed during the pandemic? Well, there are some remaining bits from that have now extended into this blueprint, and one of them comes into the eviction protection, diversion, and relief when it comes to the 30-day notice for non-payment of rent. Can you explain a little bit about that?
Yeah, as everybody, all the viewers know, I mean, if you had a Fannie or Freddie or even just CARES Act, Section 8, all of that kind of big bubble we've talked about a ton, you had to give a 30-day notice, and we're not going to delve down into the weeds on that again. But that is coming back up again. And again, in this blueprint, the White House has again said, yeah, that 30-day still is required before you require the person to vacate. And they kind of want to expand on that as well into other areas and be a bit more proactive in the rights that they give to residents through, the Fannies and the Freddies. But I think from here, what I pulled out was under the eviction prevention, they're talking about the access to resources to avoid eviction, which we can talk about, ensuring fair court hearings, and avoiding future housing instability, which those are huge issues to be undertaken.
And back to your point that individual states should have the right to make the decision about what is good for their state when it comes to notices and what type of laws they want to apply for landlord-tenant relationships. It also comes to the same when it comes to representation in court, because one of the issues they talk about in the blueprint is having access to counsel when you go to an eviction hearing, and then also what that procedure should look like as well. We're getting down into very granular or very detailed portions of procedural law in the individual states, and the federal government trying to require that all states fall under a certain category. That comes out up in terms of diversion as well. Well, what does diversion mean?
Yeah, that's what I was literally waiting for this. So this is what I think it's so funny. So they again say the fair part of the process, but also that they want to work on diversion. And so as diversion, they say, don't go to eviction court. Instead, look at other alternatives such as mediation, try and settlement, and arbitration. So where earlier they said they don't want arbitration in leases, they then suggest it later on as an alternative to an eviction, which just, again, blows my mind, but it's above my pay grade. So they're trying to look at other suggestions to avoid the eviction for the person because obviously the implications that has on somebody. But then again, like Scott mentioned, that ties in the whole concept of sealing records. They want records to be sealed, and not just ones where they've been dismissed, like we passed statutorily here as well, but even cases where the tenant had a judgment against them but actually paid and stayed. They want those records sealed so future landlords can't find that out either.
Right, and that really does pose a problem from a practical perspective. If you have an applicant that comes in and they fill out your application forms and they've answered certain questions, you need to have some mechanism so that you can verify the accuracy of the statements that they've made. And if that mechanism and that ability and tool has been taken away from you, then it's going to make it more difficult to assess individual applicants that come in for a tenancy.
Yeah, and where they finish, and they kind of just throw a little paragraph at the end of this section, and which is the end of the blueprint as well, basically saying that Freddie Mac is now going to look and kind of almost create a chart of rights on a state-by-state level, which, frankly, it blows my mind they don't have that already if they don't. But that means they're then going to dig into the states and figure out what can be done via the different states to see if people have different rights.
And we've seen some of these struggles as well in the manufactured housing communities. There's already different tenant protections, and there's already been this type of action that's been put out there to try to create these tables to see how can we try to mash a variety of different laws and make it uniform into one. And there are significant challenges in that particular area of law, as it will be when it comes to apartment complexes and single-family homes and renting it out. A cookie-cutter approach isn't necessarily always the best approach.
Yeah. And so again, just like we said at the beginning, right now, nothing legally has changed overnight. There's not like you have to go out and write a whole new policy to address everything different. You're serving new notices, doing all these things different. That's not what's happening. Right now, what we're seeing is through this blueprint, the landscape of the business is changing, and you need to be aware of that and aware of what's coming down the road. And like I said, with most of our clients, they run clean ship. They're there to provide housing, and they really do want to provide the best housing they can. And their policies already account for that. But everybody should be aware of the landscape in which they practice. So, again, I hate to say it, like and subscribe to the podcast because, hey, it's a YouTube podcast. But until next time, we'll see you on the Zona Law podcast.